outgoing Acting Deputy Chief Justice Mbuyiseli Madlanga has sent a settlement case between Vodacom and Please Call Me inventor Nkosana Makate back to the Supreme Court of Appeal. In his judgment, he noted that the SCA had failed to give reasons for overturning a High Court ruling which awarded Makate 47 million rand for his idea. The SCA finding that Makate should be paid more. Linda Mnisi joining us now for more on this story. Linda, good evening to you. So the SCA's failure here, because Justice Madlanga also points to errors by this court, was their fault them not defining exactly the amount, because the High Court had set that at 47 million?
Well, in fact, what is important, Paul, is that we go back to how we got to this point. You'd recall that in 2016, this matter was in the Constitutional Court, where it gave a directive that Vodacom, as well as Nkosana Makate, who is the inventor of Please Call Me, should go back to the drawing board, engage in good faith. And if those engagements do not succeed, then the CEO of Vodacom should then come in and make a determination in terms of the compensation, right? So those engagements happened and they basically reached a deadlock, which then prompted the CEO to come in. The CEO used different models or, checked or different models to see what would be the equitable compensation for Nkosana Makate, and then reached at the 47 million rand. But that 47 million rands was not satisfactory for Nkosana Makate. He then went to the High Court, which then set aside and reviewed, it reviewed and set aside that particular decision by the CEO to give him 47 million rands, right? But it then remitted that decision on what exactly or how much he should get back to the CEO, right? So the Vodacom was then not happy with that particular ruling. It then went to the SCA. And the SCA then, considering the appeal that Vodacom had brought, then decided to uphold the High Court's decision, but substituted the remission with what? A 5% to 7.5% compensation of the revenue that the Please Call Me product would have, generated. So instead of saying, go back to the CEO for a determination again, the SCA said, we're going to substitute that order with Vodacom having to compensate, Makate 5%, between 5% and 7.5%, right? So Vodacom then took it to the Constitutional Court, saying that, they had no jurisdiction to substitute this order, and they did not deal with the issues at hand here. And that is why we want the Constitutional Court to set aside the SCA ruling. Now, in considering what the SCA had taken, or the decision that the SCA had taken, the Constitutional Court today is saying that they made a number of errors. In some instances, they didn't even consider what was, being in dispute. They merely just mentioned what was being in dispute. So I want us to take a listen to how Justice Madlanga put it.
That the Supreme Court of Appeal, A, failed to provide adequate reasons for its judgment, B, disregarded or was unaware of certain material facts and issues before it, C, at times merely highlighted the parties' arguments in respect of central issues, but did not engage with those arguments in any meaningful way. D, failed to assess evidence that was adduced by the evidence which it ought to have assessed. And E, readily accepted whatever Mr. Makate proffered without explaining why it did so. Based on these holdings, I conclude that the Supreme Court of Appeal failed to discharge the duty of proper consideration. This failure violates the rule of law and the fair hearing right protected in Section 4 of the Constitution. My conclusion on this ground is that, absent a cross-appeal by Mr. Makate against the order of the High Court, the Supreme Court of Appeal lacked jurisdiction to substitute its own order for that of the High Court.
So essentially, the SCA going beyond its scope or its powers in substituting that particular order is what Justice Madlanga is saying. They lacked jurisdiction, so they did not have the powers to substitute that particular order, right? And now the decision that has been taken is that the Constitutional Court has upheld this appeal. And what it has done is that because it cannot deal with the merits itself, it's now remitted that particular case back to the SCA. And this time around, it's saying this matter should go back to the Supreme Court of Appeal, but be dealt with by a differently constituted panel of justices. So the justices of the SCA that dealt with this matter can no longer sit in this matter. What now needs to happen is that a new cohort, a new panel of judges need to then sit and deal with what is at the heart of the issues. Why, of this battle really between Vodacom and Nkosana Makate. This, of course, is a setback for Nkosana Makate. We spoke to him in the morning. There was a hive of activity. You'd recall it was Justice Madlanga's special sitting as well. That was his final judgment. And we asked him what his expectations were. And he said, my expectation is to get clarity. He was hoping that the Constitutional Court will put this matter to bed. But it was a setback. Let's take a listen to what he had to say.
Well, I'm still resilient. I mean, I'll forever be. We'll go to the SCA, and the SCA must just relook at the case and then provide us with the judgment that will then stand the test. The court has not decided on anything that the SCA has done except for them not to express themselves on certain things that were before the SCA. So clearly, I mean, they just need to address themselves on those. If you listen to what Justice Madlanga was saying that in terms of especially the determination of the CEO, I mean, they did not, I guess, thoroughly deal with that and why it was inequitable. And I think the High Court did that, so yeah.
An unending litigation is part of what Justice Madlanga said today. And we're going to try and take this conversation forward, Linda Mnisi, and we'll do that with a set of different eyes, someone who's written about this for a long time, and you'll know who that person is in a moment. But for the time being, thank you very much, Linda Mnisi.